Thank you so much for coming. If I haven't had the chance to meet you yet, my name is Erwin Chemerinsky, and I have the great privilege of being the Dean of Berkeley Law. I was asked to do a Supreme Court review, delighted to do that, and I'll use about half the time or so for that, and then use the remaining time to answer any questions you have, either about the cases that I'm covering or about the Supreme Court more generally, anything about Berkeley Law, or anything about law school. About 25 years ago, I wrote the first edition of a constitutional law casebook. Last fall, I finished the 7th edition. I have never done a new edition where so much had changed from the prior edition or from all the prior editions. Think about just what's happened in the last 2 years in the United States Supreme Court. The court has overruled Roe versus Wade. The court has dramatically expanded the scope of gun rights. The Supreme Court, for the first time, has said that a public school teacher has a First Amendment right to pray at a public school event. The court has imposed significant new limits on the power of federal administrative agencies. The court has effectively overruled 45 years of precedents that allowed college, university to engage in affirmative action. The Supreme Court, for the first time, has said that a business has a First Amendment right to discriminate and violate state law when it's engaged in expressive activity. On Monday, January 29th, Justice Sonia Sotomayor spoke at Berkeley Law. And the way she did it, she said that I could interview her and have a conversation with her. My first question to her was, so much has happened in the Supreme Court in the last 2 years. How are you? Her response, and I quote, was, I'm exhausted. This term, again, is filled with likely blockbuster decisions. We're talking here about rulings that are going to affect people, often the most intimate and most important aspects of their lives. And it's worth noting that for all of the cases that I just briefly referred to, there were 6-3 decisions. Every one of them. The 6 conservative justices in the majority and the 3 liberal justices in dissent. That, too, is something that Justice Sotomayor talked about with our faculty and our community. So what I want to do is review for you what's on the docket this term, what's likely to be decided between now and the end of June. In a couple of instances, the cases have already come down. I prepared a handout for you that lists the cases in the order in which I'm discussing them. I was told that if you go to the QR code in the materials, you can find the handout. I have no idea what that means. But they are there, and if you don't want to follow along now, they're there for you to refer to later with the citations of the cases. I was trying to think about, in preparing this talk, what's the best organization? And ultimately I came to, so I'm just going to go alphabetical by topic. And there are 6 topics that I want to cover. By going alphabetical, I start then with the abortion cases. As everyone in this room knows, in 1973, in Roe versus Wade, the Supreme Court held that pregnant women have the right to choose to terminate their pregnancy to the point of viability, that time at which the fetus can survive outside the womb. State laws that prohibited abortions before viability were unconstitutional. 49 years later, on June 24th, 2022, in Dobbs versus Jackson Women's Health Organization, the Supreme Court expressly overruled Roe versus Wade. The Supreme Court said that the issue of abortion is left entirely to the political process. The Supreme Court this term has 2 cases that touch on abortion. Neither involves whether there's a constitutional right to abortion. But both are going to be very important in terms of the availability of abortions in the United States. The first of these cases is Food and Drug Administration versus Alliance for Hippocratic Medicine. It's going to be argued on March 26th of this year. In 2000, the Food and Drug Administration approved a 2-drug protocol for medically induced abortions. One of these drugs is mifepristone. It's now estimated that about 54% of all abortions in the United States are medically induced rather than surgically performed. a conservative group, the Alliance for Defending Freedom, formed a conservative group, the Alliance for Hippocratic Medicine, to challenge the approval of mifepristone. They filed their lawsuit in the United States District Court for the Northern District of Texas. That district, like all districts, is divided in divisions. What's unique is that in many of the divisions, there is only one judge. So if a lawsuit is filed in that division of that federal court, they know who the judge will be. And they intentionally chose to file in a division where the judge was known to be a strong opponent of abortion rights. Judge Matthew Kaczmarek. He'd been abortion rights a foe before becoming a judge, before President Donald Trump appointed him. By the way, this is an aside. On Tuesday of this past week, the Judicial Conference for the United States adopted rules to try to prevent this kind of judge shopping, allowing cases to just go where one judge is the only possible one to hear the case. And you'll see a lot of controversy about that rule. Republicans are opposing it. But I think from a non-ideological perspective, we shouldn't want that kind of judge choosing and judge shopping. Judge Kaczmarek issued a stunning ruling. He said we should not refer to it as the embryo or the fetus. We should call it the unborn child or the unborn human being. He said that embryos and fetuses have constitutional rights from the moment of conception. He said that the FDA erred in approving mifepristone. He found any study anywhere on the internet that could possibly suggest that mifepristone was harmful and cited to it without any attention to reliability or scientific validity. And he held that the FDA erred in the year 2000 in approving mifepristone. The effect of his decision, had it stood, would be to say no longer could this drug be used to induce abortions, remembering that's 54% of all abortions in the United States. The United States Court of Appeals for the Fifth Circuit affirmed in part and reversed in part. The reversal is they said, the FDA approved this drug in 2000. It's too late to say now that the FDA erred in doing so. But the Fifth Circuit said that the Food and Drug Administration erred in making mifepristone more easily available. In 2017, and again in 2021, the FDA changed the rules concerning mifepristone to make it more easily available. For example, before 2017, it took 3 separate visits to a doctor to be able to get mifepristone. Then the FDA changed it in 2017 to 1 doctor's visit, and then in 2021 to no doctor's visits required. To put this in context, for all the other drugs that the FDA has ever approved, there's not another one where a doctor's visit was required. This also is important because now a number of states have prohibited abortion. If we're talking about medically induced abortion, much easier to get pills into the state than try to find a way for surgical abortions. The FDA did other things as well. Previously, mifepristone could be used only in the first 6 weeks of pregnancy. The FDA extended that to the first 10 weeks of pregnancy. The FDA also reduced the dosage with regard to mifepristone. The United States Court of Appeals for the Fifth Circuit said that the Food and Drug Administration's decision to make mifepristone more easily available was, quote, arbitrary, capricious, and an abuse of discretion, and violated the Administrative Procedures Act. To say that an agency decision is arbitrary, capricious, or an abuse of discretion is quite rare. It's a difficult standard to meet. And yet here the Fifth Circuit found that the standard meant that the FDA's approval of mifepristone in terms of these changes in regulation were impermissible. The Supreme Court granted review. I think there's a real question as to whether anybody has standing to bring the suit. In order to sue in federal court, you have to show that you've personally been injured. Who's injured by the approval of mifepristone? Now, the plaintiffs are doctors, and they say if pregnant people take mifepristone and suffer complications, they'll have to treat them, and it'll take time away from their patients. But this is a drug that's been on the market since 2000 with almost no side effects that require that somebody go to an emergency room or receive medical treatment. So I think the court could well dismiss this case just on standing grounds. If it reaches the merits, then the question is, did the FDA violate the Administrative Procedures Act? If this was in any context other than abortion, I'd say it's going to be an easy case for the Supreme Court to reverse the Fifth Circuit. But remember, there are 6 justices on this court who are quite hostile to abortion rights, so it's harder to predict. The other case I listed in the handout with regard to abortion is Moyle versus United States, which will be argued on April 24th. This involves a federal statute, the Emergency Medical Treatment and Labor Act. It's a federal statute that applies to any hospital that receives Medicare funds. What it says is, if a pregnant person is going to a hospital emergency room, the emergency room must provide medical care to stabilize that individual's condition. The Biden administration has interpreted this to say that if abortion is medically advisable, and if the pregnant person desires it, the hospital has to perform an abortion. In other words, if the health of the pregnant person would call for an abortion, and if the pregnant person wants an abortion, the hospital has to do so. Idaho has a law that prohibits all abortions except if necessary to save the life of the pregnant person. Well, there's an obvious tension between a statute as interpreted that would say abortion should be provided where the health of the pregnant person would call for it, as opposed to the statute that says abortions are allowed only to save the life of the pregnant person. A federal district court in Idaho found that the Idaho law is preempted by federal law in situations where the federal law would apply and would call for the provision of an abortion. Is the state law preempted by federal law? The general rule is when there's a conflict between federal law on the one hand and state law on the other, federal law wins out. State law is preempted. Again, I would think that this is an easy case, except for the context being abortion. The second area I list in the handout concerns the administrative state. One of the most dramatic changes in American government since the Constitution was written in 1787 has been the rise of the administrative state. It started really in the late 19th century, grew in the early 20th century, and then especially the New Deal. When I speak of the administrative state, I'm speaking of the whole array of federal agencies that exist. Think of the Social Security Administration. Think of the Securities and Exchange Commission, the Federal Communication Commission, the Occupational Safety and Health Administration. And I go on with these agencies. These are the agencies that protect us in crucial aspects of our lives. After all, it's the Food and Drug Administration that makes sure that the drugs that we take are safe and effective. It's the Environmental Protection Agency that exists to limit air pollution, water pollution. Many of the agencies exist to prevent unfair business practices, like the Federal Trade Commission, or the Securities and Exchange Commission, or the Commodity Futures Trading Corporation. Conservatives for years have wanted to limit the power of the administrative state. They want to make it much easier for businesses to go to court to challenge administrative regulations and have them overturned. We now have a Supreme Court that's quite hostile to the administrative state, has already imposed significant new limits, and even more likely this term. In the last couple of years, the Supreme Court has created a new doctrine of constitutional law to limit administrative agencies. It's called the Major Questions Doctrine. To go back to the case book that I wrote 25 years ago, no prior edition mentioned the Major Questions Doctrine. The new edition has a big section on the Major Questions Doctrine. We first saw it in June of 2022 in a case called West Virginia versus Environmental Protection Agency. It involved whether the Environmental Protection Agency could adopt regulations regarding controlling of greenhouse gas emissions from coal-fired power plants. Coal-fired power plants are a major source of the pollution that's leading to climate change. The Supreme Court, in a 6-3 decision, said that the EPA lacked the authority to do this. Chief Justice Roberts wrote for the court. Justice Kagan wrote for the dissenters. Chief Justice Roberts said, whether the EPA has the authority to adopt the regulation is a major question of economic or political significance. He said that the statute from Congress wasn't sufficiently specific in giving the EPA this authority. Therefore, the regulation was invalid. The Supreme Court applied this again on June 30th of 2023 in Biden versus Nebraska. There's a federal statute, the HEROES Act, that says that the Secretary of Education can waive or modify student loan obligations in an emergency. This is the authority that the Trump administration used to suspend student loan repayment obligations early in the COVID pandemic. The Biden administration continued it and then made it permanent. It gave 43 million Americans, including my guess is some of you, up to $20,000 of relief from student loan repayment obligations. The Supreme Court, in a 6-3 decision, invalidated this. Again, Chief Justice Roberts wrote for the court. He said, whether to give such student loan relief is a major question of economic and political significance. He said Congress wasn't sufficiently specific in giving the Secretary of Education this authority. Justice Kagan wrote a vehement dissent. She said the most basic principle of statutory interpretation is that when the plain language of the law is clear, it has to be followed. She says this statute says the Secretary of Education can waive student loan obligations. To understand why these cases matter so much, ask yourself the following. What's a major question of economic or political significance? What's sufficient congressional guidance to meet the major questions doctrine? The Supreme Court hasn't answered these questions. So it's an open invitation, what we're seeing now, challenges to every kind of agency regulation. I gave a talk in DC a few months ago, and after I was finished, several lawyers came up to me and said, our clients believe that everything is a major question of economic and political significance, and who can blame them? But there are two sets of matters before the Supreme Court now that could bring about quite significant changes, even going further with regard to limiting the power of administrative agencies. Initially, I listed in the handout two cases that were argued in January of 2024. And I know the handout says January 2023. It's a typo. It was January 2024. It just always takes me a while to change the date in the new year. The first of these is Loper Bright Enterprises versus Raimondo, and the other is Relentless versus Department of Commerce. And they involve whether or not the Supreme Court is going to overrule the so-called Chevron doctrine. Let me explain it to you. In 1984, in Natural Resource Defense Council versus Chevron, the Supreme Court said when an agency is interpreting its statute, a court should give deference to the agency decision, upholding it so long as it's reasonable. What does that mean? When the Environmental Protection Agency adopts a rule about how much of a particular pollutant can be put in the air, interpreting the Clean Air Act, courts should defer to it. If the EPA says under the Clean Water Act, this is how much of this effluent can be put in the water, deference should be given to the agency. The Chevron decision was unanimous. But in recent years, conservatives have very much criticized it. They don't want courts to defer to agencies. They want to make it easier for business, especially, that's being regulated, to go to agencies and have the agencies overturned, the agency decisions overturned by the courts. I've read the transcript of the oral argument in these two cases. My prediction is that the Supreme Court is going to overrule the Chevron doctrine. And what it is going to mean is that those who object to agency regulations will find it much easier to get them overturned in court. The other case that I list in this category is Securities and Exchange Commission versus Cherkessy. The Securities and Exchange Act regulates businesses. The Securities and Exchange Commission brings enforcement actions against businesses that violate its rules. Those enforcement actions might be brought in a federal court, or they might be brought in an agency proceeding. The Securities and Exchange Commission, like many agencies, has administrative law judges to hear these proceedings. And then the decisions of the administrative law judge of the agency can be appealed to court. What's involved here is a proceeding was brought against a company, and it was brought within the Securities and Exchange Commission. An administrative law judge found that Cherkesy and his business had violated the terms of the law and imposed fines on them. Cherkesy then goes to the Federal Court of Appeals. This is allowed under the statute. The United States Court of Appeals for the Fifth Circuit, and you're going to hear me talk about it a lot because it's a very conservative court, ruled that the SEC's action was impermissible and gave 3 reasons. First, they said that an agency should not be able to impose fines or penalties. Only a federal court can do so where there's the possibility of a jury trial. There are so many federal agencies that have the authority to impose fines and penalties. If the Supreme Court agrees with the Fifth Circuit, none will be able to do so. In 1977, in the Atlas Roofing case, the Supreme Court said agencies could impose fines and penalties so long as they were reviewable in court. This would take that power away. Second, the Fifth Circuit said it was an unconstitutional excessive delegation of power for Congress to let the agency choose whether to go to court or whether to go to an agency proceeding. The Supreme Court last found a delegation of power to be unconstitutional in 1935. Every federal agency acts under a broad delegation of power. If the Supreme Court revives the so-called non-delegation doctrine, literally every agency that exists can be challenged. And then the Fifth Circuit said it violates separation of powers to have administrative law judges who have protection from removal. An administrative law judge can be fired only for cause. And the Fifth Circuit said the president should be able, as the head of the executive branch, to fire anyone within the executive branch. If the administrative law judge is an agency where agency officials have protection from removal, it violates separation of powers. Seemingly, if the Supreme Court would agree with that, you couldn't even have administrative law judges with civil service protections because it would be limits on removal. We want any judge, including an administrative law judge, to have independence, to feel free to decide the case based on its facts and evidence. If the Supreme Court agrees with the Fifth Circuit as to any of these issues, there'll be a significant change in administrative law. But if it agrees to all of them, the most radical change for the administrative state since the mid-1930s. The third area that I list in the handout concerns criminal law. And the case here is Grants Pass versus Johnson that we argued in April. The issue can be simply stated. Can a city make it a crime for a person to be unhoused? In 2018, the United States Court of Appeals for the Ninth Circuit decided Martin versus City of Boise. Boise, Idaho had adopted an ordinance to make it a crime for a person to sleep in public. The United States Court of Appeals for the Ninth Circuit declared this to be cruel and unusual punishment in violation of the Eighth Amendment. Judge Marcia Berzon, I might mention a graduate of this law school, wrote the opinion for the court. And she said, everyone has to sleep. For a city to make it a crime to sleep in public when there's not adequate shelter beds is cruel and unusual punishment. In 1962, in Robinson versus California, the Supreme Court said the government can't make a status a crime. The government can't make being a drug addict a crime, is what the court held in Robinson. Likewise, the Ninth Circuit said the government can't make it a crime to be homeless. This past year, in Johnson versus Grants Pass, the Ninth Circuit declared unconstitutional an Oregon city's ordinance. There's actually 5 ordinances adopted by the city of Grants Pass that, like the Boise ordinance, made it a crime for a person to sleep in public. But the town of Grants Pass went even further. It prohibited a person from having a pillow, a blanket, or cardboard in public for the purpose of sleeping in public. So an unhoused person couldn't have a blanket or even cardboard to keep warm, couldn't have a pillow in public. The United States Court of Appeals for the Ninth Circuit, an opinion by Judge Rosalind Silver, said based on Martin versus City of Boise, This is cruel and unusual punishment. The government can't make it a crime to sleep in public, have a blanket, pillow, or cardboard in public, if there's not adequate shelter beds for people to have someplace else to go. The United States Court of Appeals for the Ninth Circuit then considered whether a larger group of judges review this, what's called en banc review. And the Ninth Circuit ruled 14-13 against en banc review. All 14 judges appointed by Democratic presidents voted against rehearing the case. All 13 judges appointed by Republican presidents voted to hear the case. Grants Pass then sought and received review in the United States Supreme Court. And ultimately, that is the question. Can a city make it a crime for somebody to sleep in public if they're unhoused and they have nowhere else to go? One of the interesting things about this case is that the cities in California, even with Democratic liberal city attorneys, like Los Angeles and San Francisco, have filed briefs in the Supreme Court urging the overruling of Martin v. City Boise and Grants Pass versus Johnson. On the other hand, advocates for the unhoused make the point that Judge Berzon did. How can it be a crime to sleep in public if there's nowhere else for the person to go if there aren't adequate shelter beds? The fourth major area that I list in the handout concerns the First Amendment. And this is a big term for the court with regard to the First Amendment, especially with regard to the internet and social media. I believe that the internet and the social media are the most important developments with regard to freedom of speech since the invention of the printing press. They have so democratized the ability of people to reach a mass audience. It used to be to reach a large number of people, you need to be rich enough to get a broadcast license or own a newspaper. Now anyone with a smartphone or access to a modem in a library can reach a mass audience. But there's, of course, a downside to such cheap speech as well. It can be very harmful. It might be defamatory, it might invade privacy, it might spread false information. I can count on less than the fingers of one hand the Supreme Court decisions that have dealt with the internet or social media prior to this year. There's 3 sets of cases this term that touch on the internet and social media. The first 2 that I list in the handout are O'Connor-Ratcliffe versus Garnier and Linke versus Freed, and they were decided yesterday. I had to prepare the handout early in the week, so it's not up to date, but I will update it for you now. Here's the issue. If a government official has a private Twitter account or Facebook account or Instagram account, and they use it to discuss government business, does the First Amendment apply? Here's the facts of the cases. O'Connor-Ratcliffe was a member of a school board in Southern California. The Garniers were parents. O'Connor-Ratcliffe repeatedly made postings with regard to things concerning the school board. The Garniers were quite critical of it and wrote on her Facebook page, disagreement. She removed their postings and blocked them. Well, they sued and said for her to remove their messages and block them from access violated the First Amendment. The United States Court of Appeals for the Ninth Circuit agreed with them. The other case involved a man who's the city manager of Port Huron, Michigan. His name is Freed. And Linke is a constituent in Port Huron, Michigan. And the manager, Freed, would make postings on social media. And Linke objected to them. So Freed removed all of his postings and blocked him for the future. Linke sued, but here the United States Court of Appeals for the Sixth Circuit ruled in favor of Freed. So the issue is, if a government official has a private social media account, does the First Amendment apply at all? If this sounds familiar, you might remember a former president who had a Twitter account and sometimes would block his critics from having future access. He got sued in both the federal district court and the Federal Court of Appeals ruled against Donald Trump. By the time it got to the Supreme Court, he was no longer president, so that case was dismissed as moot. Yesterday, the Supreme Court unanimously, an opinion by Chief Justice Roberts, said sometimes the First Amendment applies in these circumstances. Not always, not never. The court articulated a two-part test. Said, first, it has to be that the government official has the authority to speak for the government entity. And second, the person has to be speaking about government policy. So if the person has the authority to speak for the school board, or is a member of the school board, or has the authority to speak as the Port Huron city manager, and they're speaking about government policy, then the First Amendment would apply. And at the very end of the opinion, in the next last paragraph, Chief Justice Roberts indicated that the First Amendment is especially likely to apply when government officials are blocking people from having access to social media where official policy is discussed. The court didn't resolve either of these cases. The court wrote the opinion in Linke versus Freed and sent it and O'Connor, Radcliffe versus Garnier back to the lower court for a decision. But it does provide guidance in terms of when does the First Amendment apply to such social media. Two very important cases with regard to the internet and social media were argued last month. These are Net Choice versus Moody, or Moody versus Net Choice, and Net Choice versus Paxton. Moody versus Net Choice and Net Choice versus Paxton. They involve, respectively, laws adopted in Florida and Texas. Both states adopted laws saying that social media platforms could not engage in content moderation, and especially applied to larger social media platforms. Both the Florida and the Texas legislatures acted out of the view that social media platforms were much more likely to censor, to take down conservative speech than liberal speech. There are certainly studies that dispute that this is actually what happens, but it was the perception of the legislature. And so the legislatures adopted laws preventing social media companies, Facebook, YouTube, Instagram, from engaging in content moderation. Now, I'll make my editorial comment here. I think we want social media companies to engage in content moderation. Facebook takes down 4,000 hateful messages an hour. Millions every month. You might remember when there was a mass shooter in Buffalo. He wanted to broadcast over social media his shooting, and the companies immediately took it down. We want them to do that, I would think. We want them to take down sexually exploitive material, even if it's protected by the First Amendment, or material encouraging terrorism, even if it's protected by the First Amendment. But the Florida and the Texas laws would make that impermissible. The United States Court of Appeals for the 11th Circuit struck down the Florida law. The United States Court of Appeals for the 5th Circuit upheld the Texas law, and the Supreme Court granted review. My sense, from having read the transcript of the oral argument, is that the Supreme Court is going to strike these laws down. I think what it's going to say is social media companies are private. They're not part of the government. And a private media company can decide what to have on its platform. In 1973, the Supreme Court decided Miami Herald versus Tornillo. It involved a Florida law that said if somebody was verbally attacked in a newspaper in Florida, they had the right to reply within the newspaper. The Supreme Court, 9-0, declared that unconstitutional. The Supreme Court said a newspaper gets to decide what to publish on its pages. The government can't tell it what it can or can't print. And I think the Supreme Court is going to say in these cases that social media companies, like a newspaper, get to decide what content to have on their platforms. Finally, with regard to the First Amendment, I want to talk about two cases that are going to be argued on Monday, the day after tomorrow. In both of these cases, go to the basic question, when is speech by a government official itself an infringement of the speech of others? If there was hate speech within the law school, it's protected by the First Amendment, but I, as dean, would immediately condemn it. Could those who engage in the hate speech say, I'm violating their free speech rights by condemning it? Every year I send a message to the community about free speech, and I say, just because you have the right to say something doesn't mean that you should say it. that I hope that people in their speech will express tolerance and even kindness to one another, could that message be said to violate the free speech rights of our students? That's what's at issue in these two cases. Murthy versus Missouri involves the Biden administration encouraging social media platforms to take down false speech. The Biden administration especially encouraged social media platforms to take down false anti-vaxxer speech and false speech with regard to the 2016 election. 2 states and a number of conservative individuals objected to this. The United States Court of Appeals for the Fifth Circuit found that the Biden administration had violated the First Amendment by encouraging social media platforms to take down this false speech. The other case that's going to be argued on Monday is National Rifle Association versus Vullo. Maria Vullo was a business commissioner in New York. After the Parkland, Florida shooting, which killed 17 people, she encouraged insurance companies and banks in New York not to do business with the National Rifle Association. They sued her, saying her speech violated the First Amendment. The United States Court of Appeals for the Second Circuit ruled in favor of Vullo, saying she was just engaging in her own freedom of speech. There's only one Supreme Court case directly on point, and it was from 1963. It was Bantam Books versus Sullivan. It involved a commission on morality in Rhode Island. And it identified certain books as being inappropriate for children and therefore not appropriate to sell in the state of Rhode Island. And it said, after it identified these books that were inappropriate, it would encourage prosecutors to bring actions against the sellers of these books. And police actually went to stores selling these books and said, you face prosecution for doing so. The Supreme Court, in an opinion by Justice William Brennan, found that what it had done violated the First Amendment. It was coercive. There was a threat of prosecution for selling books that were protected by the First Amendment. I think Bantam Books versus Sullivan is quite different from Murthy versus Missouri or National Rifle Association versus Vullo. In neither of the two cases being argued on Monday was there any threat of prosecution. The most that the Biden administration did was say to social media platforms, if you don't deal with false speech, there's going to be more regulation of you in the future. That's not a threat of prosecution. And in terms of the National Rifle Association versus Vullo, all Maria Vullo did was encourage insurance companies and businesses to not do business with the NRA. Ultimately, both of these cases pose the question, when is speech by government officials itself a violation of the speech of others? I want university administrators, deans, chancellors, university presidents to be able to speak out against hate speech, even when it's protected by the First Amendment. I want government officials to be able to use their speech rights as a bully pulpit. If the Supreme Court finds that speech by government officials itself violates the First Amendment, will very much be chilling in limiting that expression. The fifth area that I list in the handout concerns the Second Amendment, and the case is United States versus Rahimi. From 1791 until June of 2008, not one federal, state, or local gun regulation was struck down by the United States Supreme Court. There were only a handful of Supreme Court cases about the Second Amendment, and they all concluded that the Second Amendment means what it says. It's about a right to have guns for purpose of militia service. For all, the Second Amendment says that the right to the militia service is key to the right to keep and bear arms. A well-regulated militia being necessary to the security of a free state, the right to keep people to keep and bear arms shall not be infringed. So every case had always said, you only have a right to have guns for purpose of militia service. In June 2008, the Supreme Court decided District of Columbia versus Heller. It involved a DC ordinance, which was then 32 years old, that prevented people from owning or possessing handguns. The Supreme Court, in a 5-4 decision, declared this unconstitutional. Justice Scalia wrote for the conservative majority and said that the Second Amendment protects the right of people to have handguns in their home for the sake of security. But he went no further than that. The Supreme Court didn't again address the scope of the Second Amendment for 14 years until it decided New York State Rifle and Pistol Association versus Bruin on June 23rd of 2022. It involved a New York law initially adopted in 1907 that said in order for a person to have a gun in public, it was necessary to get a permit. In order to have a permit, somebody needed to show a safety need, cause for having a gun in public. The Supreme Court 6-3 declared this unconstitutional. Justice Thomas wrote for the court, and he said that the Second Amendment does protect the right of people to have guns in public. He said the government can't limit having guns in public to show cause a safety need for having them. But then he went further. He said that the only kind of gun regulations to be allowed are those that were historically permitted. And he said historically permitted means in 1791 when the Second Amendment was adopted, or maybe 1868 when the 14th Amendment was adopted. Justice Barrett wrote a concurring opinion saying, we're not deciding today whether historically permitted is limited to 1791 or whether it includes 1868. For every other right that exists in the Constitution, the government can act at least if it shows a compelling need in order to achieve its goal. In fact, the government can discriminate based on race, or the government can discriminate with regard to speech based on viewpoint, if it has a compelling interest and there's no other way to achieve it. Justice Thomas's majority opinion in Bruin rejects that approach. He says 3 times in the opinion that the Second Amendment is, quote, an unqualified command, and the only regulation of guns that will be allowed are those that are historically permitted. This has led to a myriad of challenges to every kind of gun regulation over the last 2 years. And the first of these to come to the Supreme Court is United States versus Rahimi. It involves a federal law that makes it a federal crime for a person to have a gun if they're under a restraining order in a domestic violence case. Zaki Rahimi seriously abused his girlfriend in a parking lot. When someone came to help her, he fired a gun. His girlfriend went to court and got a restraining order that he could have no contact with her over a 2-year period. The judge, in issuing the restraining order, said that as a result, he was not allowed to have a gun during this time because of the federal statute. Rahimi was a suspect in many shootings. The police got a search warrant for his house. They went and they found there a large number of guns, and with them was a copy of the restraining order saying he wasn't allowed to have guns. He was prosecuted under the federal statute. He challenged its constitutionality in the federal trial court. He lost. He issued a guilty plea that preserved his right to appeal. The United States Court of Appeals for the Fifth Circuit ruled in favor of Rahimi. The Fifth Circuit said, in 1791, when the Second Amendment was adopted, there weren't laws that said people under restraining orders in domestic violence cases couldn't have guns. So therefore, under the analysis of Bruin, this federal statute is unconstitutional. Of course, tragically, in 1791, there weren't laws against domestic violence. In 1791, married women were considered the chattels, the property of their husbands, and didn't have protection by the law. I think that the Supreme Court is going to reverse the Fifth Circuit. My prediction based on oral argument is that the Supreme Court's going to say that in 1791, there were laws that kept exceptionally dangerous people from having guns, that this fits within it. But what the Supreme Court is going to do will matter for so many people's lives and so many laws involving guns. There's laws that say that those who've been convicted of felony can't have guns. There are hundreds of cases already just in the last 2 years about that. Laws that say that people who are undocumented can't have guns. There's laws that regulate where you can have guns in a city. There's laws that regulate what kind of guns you can have, like prohibiting things like AR-15s or large capacity ammunition magazines. The future of all of these laws might well be determined by how the Supreme Court writes the opinion of Rahimi. Rahimi was argued November 7th, so I expect it to come down any time now. But it's a hugely important case for the future of gun regulation in the United States. The sixth and final area that I listed concerns Donald Trump and the law. And there are 2 cases. One is obviously already decided, the The other will be argued on April 25th. The one that's already been decided is Trump versus Anderson. Section 3 of the 14th Amendment says that if somebody holds an office, they took an oath to uphold the Constitution, and they then participate in rebellion or insurrection, they are barred from again holding an office as senator, representative, elector for president and vice president, or any other civil or military office. I said to my students this semester that I'd been a constitutional law professor for 44 years, but until this semester, I never taught about Section 3 of the 14th Amendment. But we spent a half a class on February 7th, the day before oral argument, talking about Section 3 of the 14th Amendment. As you know, in December, the Colorado Supreme Court, in a 4-3 decision, held that Donald Trump was disqualified from being on the ballot for the Republican nomination of president by virtue of Section 3 of the 14th Amendment. The Colorado Supreme Court said Donald Trump took an oath to uphold the Constitution. He participated in insurrection on January 6th of 2021, and therefore he was disqualified from being a candidate. The Supreme Court, in result, unanimously reversed the Colorado Supreme Court, though the justices were split. There was a per curiam opinion. Per curiam just means it's an opinion of the court. Instead of having one justice identified as writing it and the others joining in, per curiam just means it's the opinion of the majority. We don't know who the author was. And the majority opinion said, we don't want states to be enforcing Section 3 of the 14th Amendment because we wouldn't want a state determining who can run for president of the United States. And then it said it should take a statute by Congress to be able to enforce Section 3 of the 14th Amendment, and Congress hasn't adopted a statute here. Justices Sotomayor, Kagan, and Jackson concurred in the judgment. That means they agreed to the result, but not the reasoning of the majority. But if you read the opinion, it sounds much more like a dissent than a concurring opinion. And in fact, somebody found hyperlinks in the opinion that indicates it was originally written as a dissent. In terms of states enforcing the Constitution, every case has to start in a state, either in state court or federal court. And it's really not the state that was going to determine whether Section 3 of the 14th Amendment was met. It would be for the United States Supreme Court to decide this for the whole country. The opinion by Justices Sotomayor, Kagan, and Jackson particularly objected to the idea that it should take an act of Congress to be able to enforce the 14th Amendment. Think of other provisions in the Constitution that limit who can be president. The president has to be at least 35 years old, has to be a natural-born citizen, has to be 14 years a resident of the United States, can't have already served 2 terms. Are those now going to require a federal statute in order to enforce them? Section 1 of the 14th Amendment says, no state can deprive any person of life, liberty, or property without due process of law. No state can deny a person equal protection of law. In 1883, in what's called the Civil Rights cases, the Supreme Court said it doesn't take an act of Congress in order to enforce Section 1 of the 14th Amendment. In the technical term, it's self-executing. The dissent also says the last sentence of Section 3 of the 14th Amendment says Congress can remove this disability by a 2/3 vote of both houses of Congress. So it would seem that if Congress wants to limit this, Congress has a mechanism for doing so. It shouldn't require prior congressional authorization. Critics argue that what the Supreme Court has effectively done is read Section 3 of the 14th Amendment out of the Constitution. Defenders of the Supreme Court's decision would say it shouldn't be for the court to disqualify the leading candidate for president. It should ultimately be for the people to decide who's going to be elected. But as you know, Trump versus Anderson says that Donald Trump can be a candidate. Courts cannot enforce Section 3 of the 14th Amendment to keep him off the ballot. The final case that I listed is Trump versus United States. As I say, it's going to be argued on April 25th. As you know, Jack Smith, the special counsel, indicted Donald Trump in federal court in Washington, D.C. It's a 4-count indictment, and it all relates to Trump's activities in trying to undermine the 2020 presidential election. Trump argued in federal district court that everything that he's accused of doing occurred while he was still president of the United States. And as president of the United States, he has absolute immunity for criminal prosecution for anything done while in office. The district court rejected that argument and said that there isn't absolute immunity from criminal prosecution. And besides that, none of the things that Donald Trump is accused of doing were about carrying out the powers of the presidency. They were all about trying to undermine the election and stay in power. The case then went to the D.C. Circuit. At the beginning of the oral argument, one of the judges asked the attorney for Donald Trump, how far would you take this? If a president while in office got Navy SEALs, former Navy SEALs, to go assassinate a political rival, would the president still have absolute immunity? And Trump's lawyers said yes. The United States Court of Appeals for the D.C. Circuit, in a unanimous decision, held that the president does not have absolute immunity for criminal prosecution, and the Supreme Court has granted review. I think this is a case that goes to the very heart of the rule of law. To me, the core of the rule of law is that no person, not the president or anyone else, is above the law. And the issue here is, does a president have absolute immunity for any criminal prosecution, for anything done, if it occurred while that person was in office? There's certainly a practical consequence to the Supreme Court granting review. The trial in Washington, D.C. was supposed to start in federal court in March. It's now been postponed. The Supreme Court hearing oral arguments at the end of April probably means there won't be a decision till the end of June. So if the court rules that Trump does not have absolute immunity, still the criminal trial there won't start for a long time. And also, just this week, former President Trump's lawyer argued that a criminal prosecution in New York, in the case that involves paying Stormy Daniels money not to reveal the affair, should also be stayed because President Trump signed the check and hid the expenditures while he was president. So we'll see what the court decides there. And it's all about, what does a president have immunity from? How far does absolute immunity stretch? So if you look at all of the cases that I've covered, I think what you can see why I say it's such an amazing time in the United States Supreme Court. You understand why Justice Sotomayor said she's exhausted. So I've left a little more than a half hour. You can ask me questions about any of these cases, or about other cases I didn't cover, or about the Supreme Court more generally, or also ask questions about anything with regard to Berkeley law, based on your couple of days here, or about law school more generally. And I'll try to take questions from our admitted students first, because I know we also are fortunate to have some of our alumni and other guests here. But you can ask me anything you want, since you're right in front of me, please. And I'll repeat the questions.
Do you have any predictions as to how the Supreme Court might decide on that final case with Donald Trump about absolute immunity?
I long ago learned that predictions are free and worth what they cost. That he who lives by the crystal ball has to learn to eat ground glass. But I'm going to predict that the Supreme Court is going to affirm the D.C. Circuit. And I think what it's going to say at the very least is there's only immunity from criminal prosecution for that which was done in discharging the duties of being president. That what Donald Trump did with regard to January 6th had nothing to do with carrying out the presidency. Or to go to the New York case, which isn't before the Supreme Court, authorizing the payment of hush money to Stormy Daniels to not reveal the affair and then hiding it in corporate books has nothing to do with being president. And I think what the court's going to say is that we're not going to extend immunity there. Because otherwise, I go to the D.C. Circuit's example. Could a president then order an assassination of a political rival? Or do anything and never face any possible consequences? That just doesn't seem right. So that's my prediction.
Thank you.
Please.
I'm someone that's interested in administrative law, so you
Sure.
can imagine it's a very tumultuous time.
Yes.
And I suspect you have some experience with this in constitutional law. Like, how are the conversations with yourself and amongst your colleagues on how to approach teaching a subject that, with the current court is just changing so rapidly? How do you handle that, I guess, kind of like lack of stability in the area of law?
Sure. And it's not just administrative law. 2 years ago when I was teaching constitutional law, I had to figure out what was I going to do in teaching abortion, knowing that Dobbs was going to be decided a couple months later. Or last year when I was teaching the affirmative action cases at exactly this time, knowing that the Harvard College case was going to come down in the spring. And I did it differently. 2 years ago, I had the students still read Roe and Casey and all the abortion cases. Last year, I told the students, just skim the affirmative action cases because I was so sure they were going to get overruled. I think you do so candidly. I think what you do is tell the students, here's what the law is, here's how the law might change, and here's how you use it as lawyers. That ultimately what I'm trying to do as a law professor is give you the knowledge and skills for you to use as lawyers. And so you need to know what the law has been. You need to know how the law has changed. You need to know how the law might change. But I can't hide from you that the law is in flux here. I wouldn't then be preparing you for practice as a lawyer. And there's tremendous discussion among the faculty about what are the implications of change, and also lots of discussion about how do we teach it. Please.
Do you remain hopeful for the future of American constitutional law, and if so, how?
My answer is remarkably the same as the one that Justice Sotomayor gave on January 29th. Let me tell you what she said, and then I'll give you my answer. My last question to her in our conversation was, I've been teaching a long time. I've never seen some of my students as discouraged there now about the Supreme Court and the Constitution. What would you say to them? And what she said was, we have no choice but to keep fighting. And her exact words were, what choice do we have? And she said, so many people gave their lives in order to get us to this point with regard to freedom and equality. We can't abandon their legacy to despair. I am very worried about American democracy. I have a book coming out this summer, and the title is No Democracy Lasts Forever, How the Constitution Threatens the United States. So I'm not naive in my answer that I'm giving you. But like Justice Sotomayor, I take hope from history. There's been such tremendous expansion of rights and equality over the course of American history. I mean, we have tremendous racial inequalities in the society. But think about what it was in 1787 under our Constitution that protected the institution of slavery. Or think about what it was in the first half of the 20th century, where southern states, and many southern parts of northern states, had laws that segregated every aspect of life. I was born in 1953, and then every southern state had Jim Crow laws that segregated every aspect of life. So in that sense, there's been advances. I think with regard to sex, at my law school in 1970, only 5% of the students were women. At our law school this year, almost 65% of the students are women. It's only since 2015 that gays and lesbians have had the right to marry under the law in every state. And I can do the same thing with regard to freedoms like freedom of speech or free exercise of religion. And so in this sense, I think Dr. Martin Luther King Jr. got it exactly right when he said, the arc of the moral universe is long and it bends towards justice. And so what I say to my students is, and it will only bend towards justice if they work to make it happen. And what gives me hope for the future is my students, and very much their energy, their dedication, their hope for the future. Please.
Piggybacking on my colleague's question, what do you think it will take to depoliticize the courts, and has the court ever been a neutral arbiter?
Question is, what would it take to depoliticize the court? Has the court ever been a neutral arbiter? I think it depends what you mean by depoliticize. The ideology of the justices has always been crucial for their decisions. If you haven't already read, you will in law school, Marbury versus Madison from 1803 that created the power of judicial review. It came out that way because of John Marshall's ideology and his views with regard to federal power in the courts. From the 1890s to 1936, there was a conservative court that struck down over 200 federal, state, and local laws safeguarding workers and consumers. The first federal child labor law was declared unconstitutional by the Supreme Court. Every minimum wage law was declared unconstitutional. That's because there was a very conservative court that was dedicated to an unregulated, laissez-faire economy to protect business. From 1953 to 1969, there was the Warren Court. Earl Warren, by the way, graduated from this law school His portrait is on the first floor. The Warren Court ultimately ended apartheid mandated by law, ended the Jim Crow laws. It did more than any court to expand the rights of criminal suspects and criminal defendants. It did more than any court in history to protect voting rights. But especially in the last 7 years of the Warren Courts, because it's a very liberal majority. Today, we have a very conservative Supreme Court. And one of my concerns for the future is American society is more politically polarized than it's been since Reconstruction. What will it mean to have a Supreme Court that's so clearly on one side of that divide and so far to the right on that divide for its legitimacy in the future? But inevitably, the decisions of the court are a product of the ideology of the justices. The Constitution is written in very open-ended language. What's cruel and unusual punishment, like in the Grants Pass case? What's freedom of speech? What's due process of law? And how the court interprets that is a function of who's on the court. I mentioned yesterday, if you were at my makeup class, that when I have an argument in a federal court of appeals, the first thing I want to know as soon as I can is, who's my panel? And there are instances where I've looked at my panel, I said, I can let my puppy argue this case, and either way, we're going to lose. And there's panels where I say, unless I really mess up, I'm going to win this case. That's not in every case, but certainly in the kinds of things the Supreme Court decides, it's about the ideology of who's there. So in that sense, we can never depoliticize the court. It's a human enterprise, and it's based on who are the human beings on the bench. Please.
When you were talking about the case regarding criminalization of the homeless,
Yes.
you mentioned that there isn't a law that criminalizes status, and you brought up the notion of not criminalizing drug addicts.
Right.
When you're criminalizing a functional aspect, a functional act related to the offense status, such as consuming or purchasing drugs, or in this case, sleeping in the streets, is that not effectively the same as criminalizing status? Or what's the distinction?
The case that I alluded to, and I did so briefly, was Robinson versus California from 1962. In there, what the Supreme Court said is, the government can't punish the status of being a drug addict. The government can punish somebody for possessing illegal drugs. They can punish them for taking the drugs. But you can't punish somebody for being addicted. You can punish volitional conduct, but you can't punish a status. The United States Court of Appeals for the Ninth Circuit in Martin versus City of Boise and in Johnson versus Grants Pass said that what these cities were doing was punishing the status of being unhoused. That if there's no place else to go to sleep, they've got to sleep somewhere. And so that's the same as Robinson versus California. Now, the Supreme Court might distinguish Robinson. The court might overrule Robinson. But I think what the court was saying in Robinson, what the Ninth Circuit was saying is, you shouldn't be able to punish somebody for something that's not in their control. Please, which was the back? Please.
So I have a question about the case. So it seems to me that the allegations regarding Trump would mirror the allegations regarding Nixon in the U.S. v. Nixon. Does that play into the precedent that's currently set?
Sure. The issue in United States versus Nixon was whether or not the Watergate special prosecutor could subpoena White House tapes to use in the prosecution of those who were involved in the Watergate cover-up. On March 1st, 1974, a grand jury in Washington indicted 7 individuals for participating in the Watergate cover-up. They named Richard Nixon an unindicted co-conspirator, saying they didn't know if they could indict a sitting president. The Watergate special prosecutor, Leon Jaworski at the time, subpoenaed White House tapes to use as evidence against those involved in the Watergate cover-up. The 7 individuals have been indicted. Nixon invoked executive privilege and said, I have the power to keep secret conversations with or memoranda from advisors. The Supreme Court in the United States versus Nixon said that executive privilege exists, but it's not absolute. It must yield where there's an overriding need for information. The court said the need for evidence at a criminal trial outweighed executive privilege. Nixon was ordered to produce the tape. But nothing in United States versus Nixon dealt with the issue of whether a sitting president or a former president could be criminally prosecuted. The issue in Trump versus United States is, can a former president be criminally prosecuted for acts that occurred while in office? So the issues are different in those cases. Let me get some more hands over here. Please.
And folks are saying they are not sure how it would, like, the court would rule, but if you look at the docket for that case, there's like all the amici, and it's like they're overwhelmingly asking the court to, overturn the ruling of the Ninth Circuit. And so, my question would be how much effect, if any, that you see in their case, like how much of any effect it would have
Sure.
for that balance, or like the lack of balance that it
Sure. Sure. The question is, in essence, for a prediction from court's decision in Grants Pass, or more precisely, how much will the amicus briefs, the friend of the court briefs, matter? I've asked Justice Sotomayor on other occasions, how much do amicus briefs matter? And she said, sometimes, and it depends on who they're from. I also have the sense from what, in fact, I've heard Justice Breyer say, the more amicus briefs that are filed, the less likely it is they'll all be read. And less may be more, and there's certainly not less in the Grants Pass case. And as you point out, as I mentioned, many of the amicus briefs urging reversal of the Ninth Circuit are from liberal city attorneys in places like San Francisco and Los Angeles. I've already told you I'm reluctant to make predictions. When I make predictions, I like to invoke the memory of my late grandmother. Whenever she would see a pregnant woman, she'd guess it's the sex of the coming baby. If she got it right, she'd never let you hear the end of it. And if she got it wrong, she'd never mention it again. My prediction is the Supreme Court's going to reverse the Ninth Circuit in Grants Pass. Somewhat, that's just based on statistics. The court reverses the lower courts in between 75 and 80% of all cases. The court generally doesn't take cases to affirm the lower court. And so that statistically gives me a good base for prediction. But also, as I alluded to, in the Ninth Circuit, the vote was 14 to 13 against en banc review, with all of the Court of Appeals judges appointed by Democratic presidents saying, we're going to let the panel opinion stand, and the 13 judges appointed by Republican presidents saying, reverse it, including in two very strong opinions by Judge O'Scanlan and Judge Mylan Smith. I think the majority of the Supreme Court is much more ideologically like the dissenters on the Ninth Circuit than like the majority. That's not what I'm saying. I hope will happen. You're asking me my prediction, and I think that they will take solace from the fact that even liberal cities are saying, overrule Martin versus City of Boise and Johnson versus Grants Pass. Question over here?
This is more of a general question, but why did you decide to become a lawyer?
If you had known me in college, I would have told you I wanted to be a high school social studies teacher. I didn't know a single lawyer growing up. Neither my parents nor brother or sister had gone to college. And I knew even at that age that I really loved teaching. And I took all the classes to become and did my student teaching and a certified high school social studies teacher in Illinois. If it doesn't expire, I'm still a certified high school social studies teacher in Illinois, but it probably expires. But I was inspired to go to law school by the civil rights lawyers of the 1950s and 60s. I said, that's what I wanted to do with my career. I believed then and still believe now that law is the most powerful tool for social change, and I wanted to be part of it. So I took the LSAT at the last day. I signed up on the last day you could take it, took it the last day you could apply for the year, got my applications in at the last day, but went to law school, and I started law school in 1975, and I've never for an instant regretted that choice. But that's why I went to law school, because I want to try to use law to change the world. Please.
I guess increasing partisan polarization in society, of course. Looking at some of these decisions, like with public campaigning for city governments or federal agencies and their abilities to enforce regulatory rules, is there any possibility these affected parties just simply disobey whatever court decision the Supreme Court chooses to pass down and any possible implications?
The question is about what is the possibility of disobeying Supreme Court decisions. I think when you're talking about cities, the answer is they're not likely to, because they'll be held in contempt, and there'll be substantial consequences for doing that. I've always worried much more of what if we have a president who says, I'm going to disobey what the Supreme Court has said. And it could be a Republican president, it could be a Democratic president. It could be a Republican president who loses in the Supreme Court on something, or a Democratic president with the conservative court. And the president just says, that's nice. John Roberts and his court made the ruling, now let them go enforce it. I'm going to ignore it. If that ever happens, then I think we've really undermined the rule of law. That then no longer are we a nation of a constitution rather than people, but then what it is that people will follow the Constitution if it pleases them. And then I think we've taken a huge step towards the end of a constitutional democracy. I often, obviously, disagree with what the Supreme Court says, but I think it's so important that we have a court that can issue final judgments that are respected. And to this point, presidents, almost without exception, have complied with Supreme Court rulings. There's a famous instance. There's a famous instance of Andrew Jackson in the 1830s, Worcester, Georgia, saying, John Marshall made his ruling, now let him go enforce it. But generally, presidents have complied with the Supreme Court. In fact, in the 1950s, Dwight Eisenhower very much disagreed with the Supreme Court's desegregation decisions, but nonetheless sent the National Guard out to enforce them. But is that a possibility? Absolutely, but I hope it never happens. Please. The question is about the shadow docket. The Supreme Court has always had an emergency docket. There's always been the ability to go to the justices for relief on an emergency basis. Think of death penalty cases, where a condemned individual goes to the court for a last-minute stay of execution. What's changed over the last 10 years is much more use of the emergency docket to issue rulings on the merits, and to write opinions, even though there's not briefing and oral argument. There are a number of cases involving restrictions imposed because of COVID, where the Supreme Court decided with opinions on the shadow docket and emergency rulings, and these seem to be binding precedents for the future. And what concerns me is there was no briefing of them, there's no oral argument of the case, and yet the court's deciding this. Steve Vladeck, a professor at the University of Texas Law School, wrote a terrific book that came out last year called The Shadow Docket, where he reviews this and shows there's much greater use of this. My largest concern about it is a technical one. Generally, a court of appeal should stay a trial court order only if the trial court decision is what's called an abuse of discretion. It's a very hard standard to meet. So generally, the Supreme Court should stay a court of appeals decision on the shadow docket only if it's an abuse of discretion. And yet, that's not the standard the court is following here. The Supreme Court is being very inconsistent on the shadow docket. Please.
I know you talked about how judges are, they're humans, they have their ideologies and stuff like that. I'm just really curious if you do traditional readings of the Constitution, going more modern, as we're evolving and changing. About gun rights and how there wasn't protection for women back in the day. How do people justify continuing to use the Constitution in ways that aren't evolving for the way our society is evolving? Do you see that changing?
On the current court, there are 3 justices who are self-avowed originalists. They believe that the meaning of a constitutional provision is fixed when it's adopted, that it can change only through the amendment process. They justify it by saying that it's the nature of a written document that is a fixed meaning at the time that it's adopted. It can be changed only by amendment. And they say this is a way of limiting the power of the judiciary. So that instead of justices following their own views, they're following the original meaning of the Constitution. That's how they justify it. I am very critical of this view. Again, to mention the title of a book I've written, I wrote a book that came out about a year and a half ago titled Worse Than Nothing, The Dangerous Fallacy of Originalism. The title tells you what I think of originalism. In part, it's because I don't think we can know what was the original meaning thought in 1787 when the Constitution was adopted, or 1791. In part, is our world is so vastly different today than it was in 1787 or 1791. It doesn't make sense to be governed by the views of those in a very small agrarian country where they allowed owning of enslaved individuals. I also think that the originalist justices don't follow originalism when it doesn't get to the originalist views, the conclusions that they want. I think that it's clear that the Congress that ratified the 14th Amendment meant to allow what today we would call affirmative action race-conscious programs, but that doesn't limit what the conservative justices have done. In 1987, Robert Bork was nominated for the Supreme Court. He had impeccable credentials. He'd been a University of Chicago and Yale law professor, Solicitor General of the United States. He was a judge on the United States Court of Appeals for the DC Circuit. Nonetheless, 58 senators voted against his confirmation, the largest ever to vote against a nominee for the Supreme Court. And they did so because they found his originalist views to be unacceptable. He believed that equal protection didn't apply to protect women or gays and lesbians because that wasn't the intent of the 14th Amendment. He believed there was no right to privacy in the Constitution because it wasn't part of the original document. He believed the First Amendment only applied to political speech. You see the change in that now there are 3 justices who call themselves originalists and 3 others who are very sympathetic and often write opinions in those terms. Please.
In light of the Dobbs decision and looking ahead to future terms, do you think that other fundamental rights that flow from the 14th Amendment, such as the right to contraception or the right to same-sex marriage, do you think that those rights might be at risk of being reversed?
I don't know. In Dobbs, Justice Thomas wrote an opinion saying, now that we've overruled Roe versus Wade, we should overrule Griswold versus Connecticut, the 1965 case that said there's right to purchase using contraceptives. Lawrence versus Texas, the 2003 case that said that states cannot criminally punish private, consensual, same-sex sexual activity. And he said Obergefell versus Hodges, the 2015 case that said there's a right to same-sex marriage. Justice Alito, in his majority opinion, said those rights are not in jeopardy because they don't involve potential life. But I also don't think that any of those cases are decided the same way today under this court. And Justice Alito said at the beginning of the opinion, a right should be protected in the Constitution only if it's a text, part of the original meaning, or a long unbroken tradition, and none of those rights would be decided as they were by the Supreme Court under that approach. I don't see the Supreme Court as holding that a state can prohibit the purchase and use of contraceptives. But there's a case now pending in the Fifth Circuit that said, a conservative federal district judge, Matthew Chemerinsky, in fact, said that it violates the Constitution to give contraceptives to minors without parental consent. And that, I think, will come to the Supreme Court. And I think the Supreme Court will at some point face whether to overrule Obergefell. I don't know that this court would do it. Same-sex marriage is so accepted in our culture. Would they really overrule it? On the other hand, Chief Justice Roberts has read only 1 dissent from the bench since coming on the court in 2005, and that was in Obergefell. Thomas and Alito also dissented, and there's also 3 more conservative judges since. So the only answer I can give is, I don't know. Please, in the back. Sure.
I wanted to ask, so a lot of cities, including Los Angeles, have passed ordinances banning camping like within a certain distance of schools, daycare centers, and parks. So to me, that kind of seems analogous to how like we don't criminalize being an alcoholic, we criminalize driving drunk, we criminalize the behaviors of a certain status that are most dangerous. So could that be a kind of like middle ground between
Yes. This is about cities like Los Angeles prohibiting where there can be encampments for the unhoused. And what's important is nothing in the Ninth Circuit's decisions in Martin versus City of Boise or Johnson versus Grants Pass would prohibit cities from doing that. So long as there is a place for the unhoused to sleep, it would meet the Constitution's requirement. And if a city wants to say, these areas are off limits, but these are permissible, that would be okay under the Constitution. It's analogous under the First Amendment to time, place, and manner restrictions. Again, keep your questions, but also if you have questions about Berkeley law or about law school, glad to answer those. Please.
Predictions in terms of rulings for the net cases that you mentioned. I think there's been a lot of increased consumer protection action from like attorney general's offices trying to deal with like the algorithmic design features of social media applications. And I'm curious if you think that the net decision will impact those numbers.
It's a great question. There's been a flurry of state laws with regard to the internet. States limiting the ability of minors to have access to the internet without age verification. Limits on what can be put onto the internet. New York had a law trying more to regulate hate speech on the internet. California has the Age Appropriate Design Act with regard to it. My concern is whether it makes sense to have states be the ones that regulate the internet. It's a national and international media. What if there is a plethora of state laws and conflicting state laws as we have? Will the Supreme Court's decisions in the net choice cases address that? Depends on how they're written. It wasn't a primary issue, but it's certainly an underlying issue of does it make sense to have states independently and on their own regulating this national and international media. So it depends on how the court writes it. I don't think it's most likely how they're going to write it, but it's certainly an underlying issue. Please, in the very back. I didn't hear. Let me come closer.
Do you think that giving private tech companies the power to use their discretion to regulate speech on the internet is a threat to society?
The question is, do I think that giving private tech companies the power to regulate what's on the internet is a threat to society? Yes and no. How's that for a typical law professor answer? Yes, I'm afraid about the ability of companies like Google and Facebook and YouTube and Twitter to so control what we can see and what we can hear. On the other hand, I'm even more afraid of giving the government the power to regulate what we can see and hear. And so I think that there are all sorts of difficult issues that we have to face because of the internet and social media. I am so concerned about how do we deal with deep fakes, especially in the political realm, over the internet and social media. And I don't think we have answers to that. So the answer is yes, I am concerned about giving social media companies the power, but I think I'm even more concerned about taking it and giving it to the government. And so in the net choice cases, I want social media companies to engage in content moderation. I want them to take down hateful speech and sexual exploitation material speech and terrorism speech. But I recognize they might use that power to take down speech that I like as well. But I worry so much more when the government says that you can't engage in any of that content moderation. So I think you put your finger on an enormously difficult question for which there aren't good answers at this point in time. Please.
Do you think there should be stronger checks on the individual actions of the Supreme Court justice? Is it morally permissible for them to be accepting gifts or taking vacations and then ruling coincidentally a certain thing?
The way you phrase the question, the answer is easy, no. Until November of 2023, every judge in the United States, state or federal, had to comply with an ethics code, except for the most important judges, Supreme Court justices. It was inexcusable that there wasn't an ethics code for the Supreme Court. I think it contributed to this unprecedented low approval rating, and that's a self-inflicted wound. They could create an ethics code. They did in November 2023, and in many ways it's the same as applies to other judges, except for two crucial failings. For all other judges, it says the circumstances where a judge shall be disqualified, shall be recused. Shall in the law is mandatory. The ethics code for the Supreme Court justices uses the word should be recused. And that's aspirational. Also, there is no enforcement mechanism in the Supreme Court's ethics code. There is, following it, a statement that says it's left to each justice still to decide for himself or herself whether to recuse in a case. So whether Justice Sotomayor or Justice Thomas is disqualified, that's left to Justice Sotomayor for her, Justice Thomas for him. No person should be a judge of himself or herself in that way. My colleague here at Berkeley Law, Jeremy Fogel, former federal judge, former head of the Federal Judicial Center, has proposed, and it was a testimony for Congress, for the Senate Judiciary Committee last June, where he said, the Chief Justice should appoint a panel of retired Federal Court of Appeals judges to decide a motion when there's a recusal asked for a Supreme Court justice. And I thought that was a great suggestion, but I don't think it makes sense to leave it to the justice to decide for himself or herself. I think we have time for one more question. I'll take it here. Please.
My question is that now that abortion based on the right to privacy has been overturned in Roe, do you have a sense that there will be a new emerging constitutional legal doctrine for the right of abortion for future advocates?
Will there be a new constitutional doctrine to protect the right to abortion? Not so long as this is the Supreme Court. These justices emphatically reject a constitutional right to abortion. Justice Alito's language in Dobbs couldn't have been more explicit, saying he thought that Roe versus Wade was, quote, egregiously wrong. I think there will continue to be efforts to protect abortion rights through the political process, but also efforts to restrict abortion through the political process. I'll make a prediction for you. The next time there's a Democratic president, a Democratic Congress, there'll be an effort to create a national law creating a statutory right to abortion and preempt states that prohibit it. But the next time there's a Republican president, a Republican Congress, they're going to adopt a law that prohibits all abortions in the United States, preempting laws like California that allow it. I think the effect of Dobbs, for better or worse, is to shift it to the political process for the foreseeable future. Someday, when there's a different Supreme Court, they could then overrule Dobbs and go back to Roe. But given the age of the justice, I don't think it's going to happen in my lifetime. Thank you so much for coming to Admitted Students Week, and thank you for coming today.